Hi, I'm Carlos Colombo, immigration attorney at Colombo Hurd. Today, we're going to talk about EB-2 National Interest Waivers. We're going to discuss the substantive requirements as well as some of the practical aspects, how to apply for an EB-2 National Interest Waiver. The EB-2 National Interest Waiver is part of the immigrant category for applicants who are seeking a green card to the United States. If you are a person that either has an advanced degree, either the equivalent of a master's or a doctorate in the United States, then that's one of the first basic requirements for an EB-2 National Interest Waiver. The second requirement that you must fulfill is to be in the national interest. And that's where it gets a little bit tricky for most folks. Now, if you don't have an advanced degree, then what do? There are other ways you may qualify for a national interest waiver. You may have exceptional ability in your field, for example, in the arts, sciences, or even if you're an entrepreneur looking to do an investment in the United States and create a company as an entrepreneur. So the first part, the very basic requirements of the EB-5 is to satisfy either whether you have an advanced degree or you're an alien of exceptional ability. What does that mean? What does exceptional ability really mean? There has been a definition over the years, not only in the regulations, but also in the case law that has been applied throughout the years as to what qualifies as a person of exceptional ability. And typically, you must meet three of those different requirements, either having a bachelor's degree in the area of expertise, or you may have a license to practice in your field. It could also be a high salary, or publications and recognitions from your peers, people that may have worked with you or may know your work in exceptional ability. There's even a catch-all where immigration will consider other evidence that may qualify you for that EB-2 National Interest Waiver. Those are the basic requirements that you need to fulfill. And those are actually outlined on the USCIS website at uscis.gov. But one thing is having these basic requirements fulfilled, and another thing is actually winning a national interest waiver application. To do that, you have to convince the officer that you will not go through the normal process of an EB-2. There are two types of EB-2s, either in the national interest, which is the national interest waiver, or the regular EB-2, which is a way for applicants to apply through the regular process through an employer, through a company in the US that will sponsor you for that green card. That is the regular process that most EB-2 applicants will apply through a US company that is sponsoring them for employment in that category. If you do not have a sponsor, or it may be impractical for you to get that sponsor, then you may self-petition, which means you do not have to have a US company be your sponsor, and you may self-petition, apply by yourself without that company for that benefit. So let's break that down a little bit. The EB-2 normal process requires the US company to go through what's called the labor certification or PERM process. That process can be a time-consuming and costly process for companies, so many of them may not be willing to go through that process, which can take, in many instances, well over 1 year to process. The labor certification process is there for a reason. That is there to protect US workers, American workers. Basically, what the labor certification process requires is that the person and the company go through a process of advertising the position and seeing if there's qualified US workers that have applied for that job position. If there are none, then the Department of Labor will certify that PERM application, and you can continue with your EB-2 process. The National Interest Waiver process basically says no. We're not going to make the applicant, the immigrant in this case, go through that complicated process and that time-consuming process of going through that labor certification. That is because it is in the best interest of the United States to not put that immigrant applicant through that process. Why is that? There's different ways you can argue why you, as an applicant, would be in the best interest of the United States. Since we're doing here an overview, I wanted to touch on one recent aspect of EB-2 National Interest Waivers that has resulted in a flood of applications and people inquiring about this process. Why? What happened? Well, at the end of 2016, the Obama administration officials at the AAO, which is the Appeals Office for Immigration, actually issued a decision called Matter of Dinosaur that changed some of the basic requirements to establish whether the person is a person of national interest or not to the US. That decision has made it much easier for certain applicants to prove that they would be in the national interest to immigrate to the United States. So what are the three things that the Dinosaur case pointed out? And what are those three requirements now that you must meet? Well, first, you must establish that the field that you're going to be working in the United States is a field that has both substantial merit and national importance. So you have to establish that what the work that you're going to be doing in the United States and your experience is something that will be national in scope and also that has merit and it will help the United States as a whole. That's the number one thing that the Dinosaur case pointed out. The second part is that you as the applicant are well positioned to carry out this endeavor. That means that you have the experience, you have the knowledge, and you have also gained enough influence in your field to be able to develop this area in the United States. And then the final point that the Dinosaur decision stated is that on balance, it would be better for the US to waive that typical labor certification process and have you self-petition, apply without the need of going through that labor certification process, which is, again, burdensome and time-consuming. Those are the requirements that the Dinosaur case, and what is interesting about that case, which came out at the end of 2016, like I said, is that it is now easier for certain applicants to apply because it has relaxed some of the rules that were in place prior to that decision. Before that, it was very subjective. Basically, an officer would have a lot of ability to decide what he or she thought about national interest. Now it is much, much easier, and it is an area which we encourage clients that may qualify to look into. A word of warning, it is not an easy application, but it is done with experienced immigration lawyers, put together in a very professional manner. The chances of success are very high. Hope you have enjoyed this overview of the EB-2 National Interest Waiver. And if you have any questions, feel free to reach out to us. Thank you.